Nirudyogi Bachao, Unemployed Bachao, dear students and rescue fighters of Andhra Pradesh and Telangana, and everybody. Today in this video, I like to discuss about IPC Section 504. Generally, wherever we go, we used to hear this number, Section 504, uh, in India and in two Telugu states. You might hear this name, Section 504 IPC Indian Penal Code, and intentional insult with intent to provoke breach of the peace. So, where we understand from this, in this video, I explain description of IPC Section 504, what is Section 504, and when can a person be held guilty for committing an offense under IPC, and when can a person be held guilty under Section 504 IPC, and what is the procedure for trial under Section 504 IPC, and what is the procedure for appeal under Section 504 IPC, and what is the punishment for intentional insult with intent to provoke breach of the peace under Section 504 IPC. Next one, can a police officer make an arrest under Section 504 IPC without warrant? Is the offense under Section 504 IPC bailable? How to get bail if charged under Section 504 IPC? Is the offense under Section 504 offensive compoundable and testimonials? Why do you need a lawyer for a case under Section 504 IPC? And related questions, I try to describe those. According to Section 504 of Indian Penal Code, whoever intentionally insults and thereby gives provocation to any person, intending or knowing it to be likely that such provocation will cause him to break the public peace or to commit any other offense shall be punished with imprisonment of either description for a term which may extend to 2 years or with fine or with both. Now I explain this in Telugu. So in a simple language, first I like to say this 504 IPC Indian Penal Code శాంతికి భంగం కలిగించే ఉద్దేశంతో ఉద్దేశపూర్వకంగా అవమానించడంను 504 కింద తీసుకోవడం జరుగుతుంది. అంటే భారతీయ శిక్షా స్మృతిలోని సెక్షన్ 504 ప్రకారము ఎవరైనా సరే ఉద్దేశపూర్వకంగా అవమానించిన, తద్వారా రెచ్చగొట్టిన, అలాంటి రెచ్చగొట్టడం వల్ల ప్రజాశాంతికి విఘాతం కలుగుతుందని లేదా మరేదైనా నేరానికి పాల్పడే అవకాశం ఉందని తెలిస్తే 2 ఏళ్ల వరకు జైలు శిక్ష, జరిమానా లేదా రెండు కలిపి విధించే అవకాశం ఉంది. ఇది 504 ఐపీసీకి సంబంధించినటువంటి బేసిక్ ఇన్ఫర్మేషన్. నౌ what is Section 504 IPC in detailed manner? First, I explain in English and then Telugu. Section 504 of the Indian Penal Code, 1860. You remember, we got freedom in 1947, and the Republic Day we celebrated from 1950. But this 504 IPC Indian Penal Code, 1860, prescribes punishment for the offense of intentional insult with intent to provoke breach of the peace. The purpose of this section is to stop people from using abusive, insulting language intentionally, which leads to provocation and causes the person being rebuked to break the peace. It's not necessary for there to have been an actual disturbance of peace for commission of an offense under Section 504 IPC. Under this, the essential ingredients that go into the making of an offense under Section 504 IPC are that the accused has intentionally insulted some person, and that the insult is such as to give provocation to the person insulted, and that the accused has either intended or known that such provocation would cause the person insulted to break the public peace or to commit an offense. In order to understand Section 504 IPC better, let us imagine the following. For example, Siddhartha intentionally, not Siddhartha, some person X intentionally abuses Y, involves the chastity of his mother and sister. He does so with the knowledge that such an insult is likely to provoke him to cause breach in public peace. X has committed an offense under Section 504 IPC, even if Y does not act upon such provocation. Now I explain this, whatever I have said just now, I explain in Telugu language. ఐపీసీ కింద నేరం చేసినందుకు వ్యక్తిని ఎప్పుడు దోషిగా నిర్ధారించగలము? ఇట్ మీన్స్ సాధారణంగా ఐపీఎస్ కింద ఏదైనా నేరం గురించి చేసినందుకు గాను ఒక వ్యక్తి దోషిగా నిర్ధారించబడాలంటే అతను కానీ ఆమె కానీ ఆ నిర్దిష్ట నేరానికి ఐపీసీ కింద నిర్దేశించిన ముఖ్యమైన క్రిమినల్ అంశాలు ఎలా ఉంటాయంటే ఖచ్చితంగా అది నేరపూరిత చర్యగా ఉండాలి. అంటే ఎట్లా అంటే కొన్ని విషయాలు ఎలా ఉంటాయంటే నిందితుడు ఉద్దేశపూర్వకంగా అవమానించడని, మరి అవమానించిన వారి వ్యక్తికి రెచ్చగొట్టేలా మరొకసారి అవమానించడం. అటువంటి రెచ్చగొట్టడం వల్ల అవమానించబడిన వ్యక్తి ప్రజాశాంతికి భంగం కలిగించేలా లేదా నేరం చేసేలా నిందితుడు ఉద్దేశించి ఆ పని చేస్తాడు. అంటే సెక్షన్ 504 ఐపీసీని బాగా అర్థం చేసుకోవడానికి ఒక ఎగ్జాంపుల్ చెప్తాను. ఎక్స్ ఉద్దేశపూర్వకంగా వై తన తల్లి మరియు సోదరి యొక్క పర్సనల్గా అంటే వారి యొక్క క్యారెక్టర్ గురించి మాట్లాడతాడు. అలాంటి అవమానము ప్రజాశాంతికి విఘాతం కలిగించేలా రెచ్చగొట్టే అవకాశం ఉందని తెలిసి అలా చేస్తాడు. అప్పుడు ఎక్స్ సెక్షన్ 504 ఐపీసీ కింద వై అటువంటి రెచ్చగొట్టే చర్య తీసుకోకపోయినా నేరం చేసినట్టే. అంటే వైని రెచ్చగొట్టినా 504 అప్లై చేయవచ్చు, వై ఏదైనా చేసినా కూడా 504 ఎక్స్ మీద అప్లై చేయవచ్చు. ఇది ముఖ్యమైనటువంటి విషయం. నౌ ఐ ట్రై టు సే ఇన్ ఇంగ్లీష్ రిమైనింగ్ ఇష్యూస్. When can a person be held guilty under section 504 IPC? For a person to be held guilty for the offense of intentional insult with the intent to provoke breach of peace under section 504 IPC, it is important for the prosecution to compulsory prove the following. Nature of the criminal act under section 504 IPC. The accused must have insulted the victim. The term insult means that the words used by the accused must be of such a nature that poses disrespect to the dignity of the victim or which causes in him a sense of humiliation and deep social embarrassment. Insult includes the use of abuses or expletives that people routinely make part of their speech, such as bastard, foolish, and so on. Examples. Such an insult should have provoked the victim. Such provocation should have been made either with the intention or with the knowledge that it is likely to cause the victim to break public peace to or to commit an offense. It is not important that the person provoked, for example, the victim necessarily follows it up with causing breach in peace or committing an offense. It is enough that the act of the accused provoked the victim to such an extent as will likely to cause him to breach peace or commit an offense. The punishable act under section 504 IPC is an insult causing provocation in the victim or not an insult causing provocation leading to an offense by the victim. This is the one way. Yes. Next, when you see the nature of the criminal mind under section 504 IPC, the accused must have committed the above criminal act of provoking insult with the intention to do so. That is, intention to insult the victim as to provoke him. A person cannot be held liable under section 504 IPC unless such an insult was intentional in nature. Hence, it is important to know when an insult intentional and when it's not. And for that, The determining test is whether, by reason of the choice of the insult, keeping in mind the background atmosphere and the circumstances in which it is used, there was every likelihood as of a breach of peace or commission of an offense by the victim. Further, for classifying a particular abusive language as an intentional insult, the court also keeps in mind what in ordinary circumstances would be the effect of the abusive language used, and not what the complaint you actually did as a result of his school temperament or sense of discipline. An intention to insult is a matter of fact and circumstances which differs from case to case and situation to situation. Nature of insult is more of a question of fact and not of law. Insult caused should give provocation to cause a breach of public peace. We discuss now about investigation, FIR, arrest, remand, and bail. First information report, FIR. Criminal procedure is set into motion with the filing of an FIR or first information report by the victim or an aggrieved person. This marks the beginning of investigation by police into the case. Arrest. FIR is soon followed by the arrest of the accused person who has allegedly committed the offense by the police and his subsequent to production before the magistrate. Such production must be made within 24 hours of the arrest of the accused person. If you want to take custody or a remedy, we call it as custody. Sorry, remand or custody. At the time of such production of the investigation, officer believes that the investigation cannot be completed within 24 hours. For example, the police need more time with the accused for the purpose of interrogation, etc. The officer will file an application before the same magistrate seeking an extension in custody of the accused. Now, depending on the discretion of the magistrate, such detention may be authorized in police custody, lockup, or in judicial custody, jail. However, it is to be noted that a magistrate cannot authorize detention of an accused in police custody for a period exceeding initial 15 days from the date of production of the accused before the magistrate. On the other hand, a magistrate under section 167 2A CRPC may authorize the detention of the accused in judicial custody beyond the period of initial 15 days if he is satisfied that adequate grounds exist for doing so. However, no magistrate shall authorize custody for more than 90 days where the investigation relates to an offense punishable with death, imprisonment for life, or imprisonment for a term not less than 10 years. 60 days where the investigation relates to any other offense. Bail, if we talk about, if upon the expiry of 60 or 90 days, as the case may be, the police is unable to complete the investigation and to file a charge sheet as correspondence of the offense with the magistrate, the accused is entitled to default bail. That is, such bail is compulsory granted to the accused provided he applies for and furnishes bail. However, during the 60 or 90 days period, as the case may be, while the accused is still under custody of the police or otherwise, he may keep pushing for the grant of regular bail under section 437 or 439 CRPC by the magistrate or the High Court of Sessions, respectively. Filing of final report by the police. The police, after completing the investigation, have to file a final report under Section 173 CRPC. This marks the conclusion of the investigation, which is aimed at collective evidence surrounding the commission of the offense. The final report may take one of the following forms: closure report and a charge sheet. Now we discuss first about charge sheet. If the evidence collected against the accused is found to be sufficient, that is, there is enough evidence to support prosecution of the accused before a court of law and that justifies his continued detention in the custody, then the police will file a charge sheet under section 173 CRPC and will forward the accused under custody to the magistrate under section 170 CRPC. A charge sheet is a formal police record which is drawn out in a format prescribed by the state, stipulating the various particulars relating to the case, like names of the parties involved, nature of the accusation leveled, list of witnesses, statements of witnesses recorded during their examination under section 161 CRPC, whether any offense appears to have been committed, and if so, by whom, whether the accused has been arrested and whether he has been forwarded in custody under section 170 CRPC, or whether he has been released on his bond, list of objects seized under, and other documentary evidence that the prosecution seeks to rely on. Once the magistrate takes cognizance on the charge sheet, he shall issue summons or warrant depending on the nature of the offense committed to the accused, thereby securing his attendance before himself on a given date. The magistrate on the date fixed will conduct a hearing on charges and may consequently either discharge the accused and close the case, or he may frame the charges against the accused and post the case for trial. This is about 504, section 504.